In this video, we're going to be talking about bond reductions in Indiana. This is an important topic because if somebody's arrested, they typically have to post some sort of bond in order to get out of custody and get pretrial release. And it's important to understand what a court looks at when setting bond, and if bond is too high and you need to reduce it, we're going to talk about the factors that a court looks to in a bond reduction. So hopefully by the end of this video, you know a little bit more. So about me, my name's Nathan Vining. I'm a criminal defense attorney here in Indiana, and I help people with all sorts of pretrial release issues. And the important thing about understanding bond is that the goal of it is to ensure court attendance. The reason somebody has to post a bond is that it's a significant amount of money, enough to ensure that they're going to remain attending court throughout the duration of the case, because there's actually some money on the line or skin in the game, so to say. So they encourage defendants to appear in court, and that bond basically allows a defendant to be released. It's important to know that the court can, in addition to having someone post bond, put other pretrial release conditions in place, such as requiring pretrial home detention or GPS monitoring. They could even require certain kinds of alcohol monitoring or drug testing. So it's important to get an attorney, because a lot of times you can argue as to what those pretrial conditions should be, and an attorney can help ensure that the restrictions are as minimal as possible to allow living your life while out on pretrial release in a case. But also the court post bond and in high-level cases as well. It's all a matter of negotiation. So if you are arrested, typically the person is going to be taken into custody. They're going to be brought in for an initial hearing where the rights are read to them, and a lot of times they post the bail amount before or after that initial hearing. And you're going to be able to find that at mycase.in.gov. A lot of times there's going to be a entry on the case summary that discloses how much bail is set at. And if it's an amount that's too high, you then have to put in writing a request for a bail hearing. And essentially what you're indicating is that the amount is too high, and that for various reasons, it could be community, it could be on some kind of undue hardship, that bail is too much and it's not reasonable under Indiana law. So you would have a bail hearing, the judge would make a decision, and then hopefully you would be able to post a lower bail. And then basically after that kind of arrest process, the rest of the pretrial process would just go forward from there. So essentially in Indiana, the law of the land is that the Supreme Court has said that all bonds must be reasonable. And that's a very situational standard. It's reasonable is a broad term. Essentially, the court's going to be looking at the safety of the community as well, the offense charged when setting. So a lot of, if the bond is set too high, I would request a bail hearing. And what I'm going to be looking at in this kind of hearing is essentially I'd look to the defendant's community ties. I want to see, are they from the area or not from the area? If they're from the area, I would definitely include that in a bond motion and argue that the person has substantial ties to the community in a bond hearing. I'd argue employment status or employment history. Ultimately, I'd hope the person is employed, or if not, can talk about how they're going to be obtaining a job, so while they're out on pretrial release, they can be productive. We're going to talk about family ties in the community. If you have kids in there, or custodial issues where you need to raise children, that's important for the court to know, and it could be weighed into a bond hearing. We would look at criminal record. Do you have a history, or have you failed to comply with court requirements in the past? It's important to know. And then one of the things that really hurts in these kinds of hearings are prior failures to appear in court. If you have a history of prior failures, it can be harder to get the judge on your side and get a bail reduction in your case. But those are some of the common things we would look at in a bail hearing. So if you or a loved one is ultimately in custody and you're dealing with bail issues, give me a call. I'd be happy to look at the case, review what the bond schedule is in that county, what the current bond is set at, and talk about what we could do to argue a lower bond in that situation.